Mayor Succi? Mayor Succi, aye. Stone? Stone, aye.
Congratulations, your measure is out.
Thank you very much.
Let's turn to item number 18, AJR number 1.
Okay, Mr. Chairman, members, I'm here to present AJR-1, which is a measure that would begin the process to amend the United States Constitution to address the Citizens United versus the Federal Election Commission decision. You know, in a couple of years, people in the state of California will be going to the polls to elect or re-elect our senators. And I'm sure in a couple hours, members of this committee, and I won't pick on anybody, will be going across the street to enjoy a drink. And both of those are possible, and I'm talking about the direct election of senators, the 17th Amendment, and the repeal of prohibition, the 18th Amendment, because of movements like this. Our founding fathers, when they drafted the federal Constitution, they put in two mechanisms for amending it. The first one, of course, is the traditional mechanism. That is to have Congress pass by a two-thirds majority a proposed amendment, and then the states to ratify it by a three-quarters supermajority. They also put in a second mechanism, and that mechanism allows the states to, in effect, rise up and say, Congress, you have not acted. We are demanding that you act. And then Congress would have to call a convention on the topic, and then it would go back to the states, and I stress that, it would go back to the states to be ratified by a three-quarters supermajority. So in the past, when Congress has not acted, and I mentioned the 17th Amendment, I mentioned the 18th Amendment, there's other examples, the states, the state legislators, the people closest to the people in the United States of America, have risen up and passed resolutions like this, binding resolutions. We urge Congress to do a lot of things on the floor. And I'm always, the guy on the floor who's laughing quietly, when we're urging Congress to urge the government of Somalia, to urge the United Nations to do, This has teeth. This actually would be a binding resolution, and it's one of the few times, this is a unique and arcane constitutional procedure, where the legislatures, the governors don't need to sign it, but the legislators of the state, the people closest to the people, can rise up and say, Congress, you have to act on this issue. In those last instances, the ones I gave, the 17th and 18th Amendment, Congress took note. When you started to see this becoming a groundswell, you started to get towards the two-thirds of the states who had passed resolutions like this, Congress took note and they finally acted. They repealed prohibition, they allowed for the direct election of senators. And that's the goal that we're hoping for here. The Citizens United decision, most of you are familiar with it. Obviously, that is the one that caused so much ability for late-night talk show hosts to joke that corporations are people too. It really did change a tradition in this country. And I'll direct this portion of my comments to the members of the other party on this panel. A lot of the Supreme Court justices who are Republican appointees are, as you know, they're originalists. They're people who believe that the Constitution should be interpreted in the way that it was originally drafted. And I would submit that the idea that a corporation had free speech rights to our founding fathers would have been so ludicrous and just laughed out of the wonderful halls in Philadelphia. Corporations at the dawn of our country were essentially chartered entities that existed for shipping. It was the idea that shipping was so inherently dangerous that if you were sailing from England to the United States, you had to get this thing called corporate limited liability, because if your ship sunk, it could make you go bankrupt. And they wanted to make sure that people actually sailed from England to the United States. So we created this corporate entity, and a corporation has always been a thing. It will always be a thing. It will never be a person, in my book. And it's also something that speaks through its, let's put it this way, all the shareholders in a corporation have the right to free speech. All the people who work for a corporation have the right to free speech. But the idea that the corporation itself has a right to free speech, the idea that that money is speech, it should offend every single one of us. Because you know what? I'm not that wealthy, and I don't think, I've checked some of your Form 700s, neither of you are that wealthy either. And when we say that money is speech, and that somehow the very, very wealthy have the right to more speech than you and I, that's where I start to have a problem. And that's why the Citizens United decision is so problematic, and that's why it needs to be repealed. So again, this resolution is very simple, and it's your chance to participate in a very, very important procedure that's outlined in Article 5 of our federal Constitution, and that is it allows this legislature to demand that Congress call a convention for the narrow the narrow express purpose of dealing with the issue of corporate contributions to federal independent expenditures. It's a very, very narrow purpose. Congress cannot exceed the scope of this call. We are granting Congress this authority. They cannot exceed the scope. This is a very, very righteous proposal, and I respectfully ask for your aye vote.
Witnesses in support?
Thank you. My name is Austin Price. I'm the field director with the California Public Interest Research Group. We're a nonpartisan, nonprofit, member-based organization. I'd like to thank Assemblymember for tackling what we really see as a fundamental threat to our form of self-government. And our democracy is built on the basic principle that people, regardless of gender or race or religion, are politically equal. One person, one vote. Yet, in equating money with free speech, the Supreme Court has essentially said that some people should be more equal than others and have a louder voice in our democracy. And in this past presidential election, it took just 32 mega donors to super PACs to equal the almost 4 million small contributors to both Mitt Romney and Barack Obama. So if money is the same as speech, then those individuals were able to speak with more than 100,000 times the amplification of the rest of us. Secondly, the more than $1 billion that was spent in just the presidential race, more than 30% of that was dark money, and more than 12% of that came from for-profit corporations, drowning out the voices of the rest of us. And also there was a significant increase in negative advertisements, which affects turnout and how people perceive elections. Then finally, the impact is even more severe on down-ticket races where the candidates aren't as well-defined or aren't as high profile as in national elections. Imagine $1 million coming from outside your own district in your race for re-election. And so the final thing I'd like to point out is that in your vote today, the public is behind you. Poll after poll has indicated that Americans overwhelmingly, regardless of party, support overturning Citizens United. 9 in 10 Americans say corporations have too much power in our democracy. 8 in 10 Americans support overturning Citizens United. And this past November, red states and blue states, Montana, Colorado, and dozens of cities on the ballot approved this with greater than 70% support to pursue a constitutional amendment. So it's not often that you get a vote on something that this clearly plays to our central understanding of self-government. So I respectfully ask for your aye vote. Thank you.
Next witness.
Thank you, Mr. Chair and committee members. I'm Trent Lang, president of the California Clean Money Campaign. We're a nonpartisan, nonprofit, member-based organization with 15 volunteer working groups across the state and over 70,000 supporters working on the problems of big money in politics. Citizens United unleashed the floodgates of unlimited spending in campaigns, worsened an already broken campaign finance system, as you know, in which candidates have to fear being attacked by millions and millions of dollars of dark money by super PACs and hidden special interest, in which regular voters' voices are drowned out. The fact that more than 150 localities nationwide have passed these sorts of measures calling for the end of Citizens United and saying that money isn't speech clearly shows, as Austin pointed out and the Assemblymember pointed out, the huge support in the public calling on Congress to do a constitutional amendment. The problem is that all of these measures are symbolic. The sad fact of the matter is that there are two chances that Congress, 2/3 of Congress, is going to act to put a constitutional amendment on the ballot without being forced to by the states, and those chances are slim and none. It's just not going to happen when so many members of Congress rely on big money themselves for their own elections. That's why the states have to act to force the issue. And the one way California can act is with this measure, officially applying for an Article 5 convention to declare that money does not constitute speech and may be democratically limited. Some people are nervous about the possibility of runaway conventions. We've heard that concern. But as Assemblymember Gatto has outlined, AJR-1 has protections against doing that. It would be very narrowly drawn. Furthermore, 3/4 of the states would have to ratify any amendments that are proposed by any constitutional convention that actually happened. So obviously the vast majority of states will have to approve of any such amendments. But even separate from those protections, history shows that it's not likely to happen. What's likely to happen is, in the case of the 17th Amendment, calling for the election of senators once it is clear that the states are going to be calling for the convention, 29 states in that case. Once it's clear, then Congress will act. They acted in the 17th Amendment case and the case of the 18th Amendment due only to the actions of states similar to AJR-1. So we believe it's the only way to force Congress to act, and it's the only way that elected officials like you and the voters will have the chance to pass reasonable laws to limit unlimited spending in campaigns. So we'd like to thank Assemblymember Gatto for putting forth this important measure. Thanks those of you who have supported other measures to address unlimited spending in campaigns, and we respectfully ask for your aye vote.
Others in support, please come forward. Sir?
Chairman Mike Green, California State Grange. We support this bill and encourage your action on it, favorable action on it. We've got about 10,000 members. We are not a radical organization. We believe that money is not speech, and we encourage you to pass this bill. Thank you.
Others? Those opposed to the AJR-1? Seeing none, members' questions. Vice Chair Wagner?
I'll bite. I'm not going to debate, frankly, because it's not worth any of our time, my understanding versus yours of either Citizens United or the issue of money in politics, or that money is speech. I will note, simply for the record, that the equation of money to speech goes back to Buckley versus Vallejo, which was not an overwhelmingly Republican court. It was a court that existed probably well before the idea of originalism found its legs, and so to lay this whole problem at the feet of Republican appointees who believe in originalism is, I think, historically inaccurate. I won't further debate, because you and I have had this debate both on the floor and privately, Citizens United. I will merely suggest that one of my oppositions to this bill is that it is not narrowly tailored to the goal that you've got. You're calling for a constitutional convention. The issue of a runaway convention is very much real. The one constitutional convention we have seen in the history of this country arguably was a runaway convention, because the Articles of Confederation did not provide for the Constitutional Convention to do what it did. I think the result was a good one we will all support. I have no confidence that we will get it right were we to try it again. A bill calling for a repeal of Citizens United, an amendment to repeal Citizens United, I still wouldn't support, but would be narrowly tailored to what you're trying to do, not a broad call for a constitutional convention. So for those reasons and lots of others, and since you did specifically address some of your comments to me and engage, I'm going to give you the courtesy of explaining why I don't feel that I can support this bill at this point. Thank you.
Mr. Gatto, let's assume that there are other states that passed limited constitutional amendments to address this issue. And let's say Congress agrees that we're going to hold a constitutional convention for the limited purpose of addressing this. There's still some scholars that say once the convention opens, it's plenary in its charge. And there's a series, and this runaway opportunity comes forward, and they address the Citizens United issue. Isn't one of the safeguards, constitutionally speaking, that 3/4 of the states must approve whatever it was, even if you're wrong, even if you're wrong in your suggestion? Isn't that the what do we say in baseball? The backstop.
Yes, and thank you very much for that question, and it really raises an important point. So I'll address this issue of the runaway convention, which I think is, as we used to say in law school, a major red herring. Mm-hmm. So first, there's a long tradition in the law. I'm not aware of any case in the history of Anglo-American jurisprudence that would somehow diminish the concept that a scope of power is only as great as the scope of the power granted. So if I say, Mr. Wagner, you're my agent for negotiating a new cell phone contract, and you go negotiate me a contract to play in the big leagues, like, that's not proper, right? The scope is only as great as the initial grant of power or the initial scope granted. Just to correct the record, because you said that this is this broad AJR, the language says for the sole purpose of amending the United States Constitution to limit corporate personhood and declare that money does not constitute speech, thereby overturning Citizens United. That's a clear limitation.
Right, which is why we use the word runaway convention as opposed to a convention properly cabined. That's the concern.
Okay, but so if the convention, first of all, if Congress called a convention and said, you have this ability to do anything. You can go out there and overturn for the First Amendment. You can go out there and get rid of freedom of religion, get rid of the freedom of the press. First of all, right at that moment, there would be a lawsuit because the original scope that was granted by the states, which have the power to grant this authority by the Constitution, that would have already been exceeded the minute that Congress called a general convention. So there'd be a lawsuit. And the Supreme Court would have to interpret it based on hundreds of years. And then you're saying, okay, so then what if the convention delegates got together and said, gee, we're going to overturn the First Amendment? Well, first of all, I don't think that would happen. Second of all, that overturning would then have to be ratified by 3/4 of the states that had just called for this convention on this narrow issue. So there's a safeguard in our Constitution.
And in my remarks, I said I don't entirely trust the
people of the United
not
States?
the people, not the people at all. The folks,
delegates of the people.
Folks that are going to be in this constitutional convention. First of all, I am not convinced that the First Amendment would be off the table because, frankly, I think what you're doing is attacking the First Amendment. The right to petition, the right to assemble, is at the core.
Mr. Wagner, it's not an assemble.
No, let me just.
You've interrupted me several times. It is not an assembly to contribute millions of dollars through a corporate vehicle to do an independent expenditure. It's not the right to assemble.
And there is a First Amendment question there that, number one, I don't know that you've got right, but number two, I'm not sure it's the First Amendment I worry about. It's the Second, it's the Third, it's the Ninth, it's the 10th. That a runaway convention can address. That's all. I mean, you're not going to get my vote on this one. I'm sorry.
I understand. I understand, but I have to in my close just address some of these issues because the notion that the people have the power to amend the Constitution, which the people have regardless of Mike Gatto and regardless of this AJR, and the notion that we're going to all get together here today and say we wouldn't trust the people to amend their own document, that's why I say it's a red herring. The question, the initial question is itself invalid. The people can already do this. If the people wanted to get rid of the Second Amendment tomorrow, they could. It's their power, it's their Constitution, but I'm just saying there are some safeguards in place. 3/4 of the states would have to ratify whatever is done at this convention. 3/4. I don't think 3/4 of the states are going to get rid of the First Amendment or the Second Amendment or the Fourth or the Ninth. And I share your respect for those amendments, right? I love those amendments. But I feel confident in the people of this country, and I feel confident in 3/4 of states having to ratify. And unless there's other questions, I'll let that be my close.
No. There's a motion, and there's a second. You may close.
Question.
Oh, I'm sorry. Mr. Alejo has a question.
Mr. Gatto, you said this was a simple measure, but it is a very important one, and I think it's worthy of a good debate in this Judiciary Committee, and argument shouldn't be taken lightly. And I thank you for your leadership on this. This is a very pressing constitutional question for our state and for our country. And the reason that it's difficult and the reason that there's much debate among constitutional scholars is there isn't much precedent, there isn't much clarity regarding this matter. But first of all, and I wasn't on this committee last year, but there was a similar resolution, I think, by Assemblymember Allen. Similar concerns were raised in this committee by members last year. What distinguishes your bill from Assemblymember Allen's bill that failed to get out of the Judiciary Committee?
Well, a number of things. We have taken additional amendments to very, very scrupulously and carefully narrow the scope of the grant of power for this convention. We have made sure that we have tried to address some of the issues on that, and we've done everything from calling in constitutional scholars to weigh in on this bill to making sure that the language of this scope is narrowly tailored as humanly possible, so that it's really crystal clear what we're trying to do here. And I probably ought to address that just again. Look, if I had my druthers, Congress would act. Congress would act. But as I started, as I opened my comments talking about the 17th Amendment, the direct election of senators. I mean, folks know, right? Senators used to be elected by legislators. The legislature of the states would get together in dark, smoke-filled rooms, and they'd elect the United States senators that way. Prohibition, obviously. Most people are familiar with prohibition. These movements by states, when Congress was not acting quick enough in the past, I mean, prohibition languished on our national constitutional book, for lack of a better word, for years. The direct election of senators, this was a movement that really, people were feeling that rightfully it took too long. So what the states got together and did is they passed resolutions like this to force what they thought were do-nothing Congresses in the 19-teens. And by the way, we feel right now, most people feel that we have a do-nothing Congress right now, to force them to actually act. And so if I had my druthers, yeah, Congress would actually act to amend the Constitution to deal with this issue. And I feel pretty confident, as the witnesses in support indicated, that this is not a Democratic or Republican issue. And I'm a little bit disappointed that it's sometimes cast that way. I've been disappointed up here a lot before. But I note that the states that have been the most outspoken, in addition to like California and New York, the traditional blue states, have been red states like Montana and Arizona and Colorado. Those states have a profound and long tradition of saying that big corporate interests and big corporate money doesn't have a place in politics. So, I would hope that if California passes a resolution like this, if New York follows, and then Montana, Arizona, Colorado, we'll have blue states and red states speaking in unison, and then Congress will act. And they'll do it the traditional way, and we'll actually have an amendment that goes around to the states coming from Congress.
And Mr. Gatto, going back to my original concern, because I agree with you on the merits and why you are pushing for this resolution, solely behind it. My only concern is regarding just the legal procedural questions, because according to the analysis, there was some constitutional treatises that pointed out that this particular process, which you're trying to narrow in scope, has never been used to amend the Constitution. In fact, the 27 amendments to the Constitution have all been proposed by Congress rather than a constitutional convention. And I know your witnesses had mentioned some how the 17th Amendment was dealt with, but certainly this procedure it's unclear how it will work because it's never really been tested, and I'm not sure if there's precedent or prior case law regarding it. But certainly, as the analysis points out, Article 5 of the Constitution doesn't provide clarity. It's silent on this very matter, and whether once a constitutional convention is called, whether it would anyone would be able to limit, even despite the language of a resolution approved by the states. So that's where I'm trying to get at, is trying to get to those concerns, whether in fact, even though your language is limited only to this one issue, whether Article 5 in the Constitution would certainly have supremacy over that, and it would open open up the Constitutional Convention for not necessarily overturning amendments, but certainly there could be a hostile amendments done to amend the Constitution, and rather than sticking to the limited focus, next thing you know, have big legal debates on other amendments within our Constitution.
Yeah, I'm happy to address that again. So the tradition in that, unless someone can point out to me that I'm unaware, but grants of authority are only as significant and only as broad in scope as the grant. So the power to grant authority here is vested in the states. The states, starting with us, have limited this grant of authority to be very narrow. So the language of this resolution states specifically that the convention could be called only for a purpose. So if the delegates were to act in excess of that purpose, if they were to exceed that scope of authority, they would be acting with no grant of authority. They would not have the authority to act. Secondly, as our chairman noted, there is a backstop in place, which is 3/4 of the states. So 2/3 of the states can call for the convention, but 3/4 of the states would have to ratify the product. So let's say they did something crazy. You know, it would come back to you, back to us as a legislature to ratify it. So I feel pretty confident that to hit that high bar of 75% of the states concurring in whatever this convention proposes, that it would have to be something that's sensible. And that's why I feel confident submitting this resolution and supporting it, and that's why I would hope you would too.
Well, Mr. Gatto, I'm going to support this resolution certainly, but it does. I just wanted to lay out that even amongst us as members of this committee, we are concerned only because my real question wasn't whether you could limit the scope, but whether there was precedent for that. And clearly, from what I could see, there isn't precedent that gives clarity or guidance to us as members of the legislature that this indeed will be narrowed, as you argue. It could very well be, but it would likely be that if this were to ever get this far, it would probably be challenged in court, and it would be again the same Supreme Court that decided Citizens United that would be making a decision whether you could limit the scope of a constitutional convention. So I just wanted to lay out that there is concerns, but certainly the issue before us merits trying to push the debate nationally and certainly have this addressed in the future. I think it was a really unfortunate and bad case law that certainly needs to be rectified in the future, and I think it will be one of those cases that years down the road we'll look back on, and it was one of the worst decisions by the Supreme Court.
Thank you very much.
Mr. Marisucci.
Yes, thank you, Mr. Chair. I just wanted to add my support for Mr. Gatto's resolution, but at the same time I believe that the concerns raised about the uncertainties of this Article 5 convention, being nothing more than a red herring, I would respectfully disagree with that. The committee analysis does cite two leading constitutional scholars, Harvard Professor Lawrence Tribe and Yale constitutional scholar Walter Dellinger, and I will not be as brazen to say that I know more about constitutional law than these two recognized constitutional scholars. But I think it's just important, and I respect and commend you, Mr. Gatto, for pushing the envelope on this national debate, because I think the bottom line, as you indicated, is that whether we're Democrats or Republicans, the status quo is not in the national best interest, and we as California need to push the envelope on this national debate, and so that is why I will be supporting your resolution.
Thank you. And just on that, I will note that I don't presume to know more than Walter Dellinger, but I did practice law with him, and I took a case to the Supreme Court with him, and maybe next time I'll get him to testify on this, because I think I can convince him otherwise. Thank you.
And with that, Mr. Gatto, if you'd like to close or add anything else you'd like to?
I will mercifully just ask for an aye vote.
Very good. There's the first and the second. Please call the roll.
Wachowski?
Aye.
Wachowski, aye. Wagner? Wagner, no. Alejo? Aye. Alejo, aye. Chau?
Aye.
Chau, aye. Dickinson? Garcia? Gurel? Mainshine? No. Mainshine, no. Marisucci? Aye. Marisucci, aye. Stone? Aye. Stone, aye.
That matters on call. You need one more vote.
Thank you very much.
Let's move to item number 9, AB 381, by our colleague on the Judiciary Committee, Mr. Chau. This is addressing estates and trust and undue influence. And then Mr. Alejo will be next. Hit the button. Hit the button.
I have for your consideration this morning two bills. I'd like to start off with AB 267. And for the record, I'd like to state that I'd like to make author's amendments as noted in the analysis to fully harmonize the lawyer referral privileges as proposed by this bill with the lawyer...
Mr. Chau, hold a minute. Just so everybody knows, item number 22 was pulled from the consent calendar, and that's the measure that Mr. Chau will be addressing first, which is AB 267 on lawyer referral services and the client privileges. So let's address it. Please proceed. Sorry, just so everybody's on the same page.
Let me just reiterate. I'd like to say for the record that I'll be making author's amendments